and we have a number of late. I think both Minister Chuck, the AG, and Mr. Jackson is on the way. Should be here pretty soon. All right, so we could begin proceeding. Now we have we had reached the last section of our summary, which was new provisions to be included in the Act. But further, we have an appeal from the DPP's office to look at where is it now? Including two items in it. Do you think we take those two now, members, before I proceed with the rest? Mr. Williams, right? Well, look, it's not request by the DPP to look at including in the Act simple as the person to Section 5 of the last Act and receiving stolen property person to Section 46 of the last Act. Am I right? All right. We need to hear the case. There have been comments from both other departments of government, legal departments. So let's hear.
Thanks, Minister. Well, I must apologize for the absence of the learned Director of Public Prosecutions. And we are indeed grateful for the opportunity to make proposals for changes or amendments to the schedule to the legislation. I must say that when you consider the legislation in its entirety, and from our experience prosecuting matters that are currently before the court, or even giving advice in furtherance of the investigations, it's a new piece of legislation, and the jurisprudence around it is developing. And as such, we'll learn from the experiences. Thus far, we have had challenges in prosecuting the offenses because as we understand more about gang activities and really what the courts will require and the hurdles that we have to jump in order to satisfy the interpretation of the legislation and in order to bolster what it is that we're trying to prove, it is evident that there are certain amendments that will enable us to have more efficient conduct of matters before the court. We have, since the enactment of this legislation, charged in excess of a couple hundred persons under legislation alone. To date, we have about 16 matters before the court. Today, we're prosecuting one matter that has over 20 persons. And Defense Counsel is doing closing address now as we speak. And from our experience, we're proposing that that Section 5 of the Larceny Act be included in the schedule to the Act to enable us to have more efficient conduct of matters before the court. Specifically, too, we have noted Section 46, which is receiving under the Larceny Act. And from our experience in the Uchen's Wilson matter, that is the matter that is currently before the court with over 20 accused persons, we have encountered some difficulty. And because of those difficulties in proving these offenses as gang-related activities, we have had to concede where it concerns some of those persons because they are not listed in the schedule as serious offenses. So we're proposing that those amendments be made because when you look at it, gangs are what I will term very well-oiled machinery and will rival businesses in terms of their organizations. Different persons have various roles, they have different activities, and the scope of their reach is far. So when you look at it, they're involved in theft. It goes to animals, car theft, trade of certain items, illicit activities such as lotteries.
Explain to me that I know the law will certainly understand. So for me, the layman listening in, right? Mm-hmm. What is a simple larceny is define that for me because I know if they are caught
stealing.
Yeah, as Steve said, that if the thief of a TV,
yes,
it can become there. So because a gang, as opposed to armed robbery of going to a supermarket and hold up for $10 million. It's a different kind of activity.
But simple larceny is just what a layperson will probably define as stealing.
Right.
But it is not listed in the schedule
So
as a
if
serious.
a gang is involved in stealing televisions,
Yes.
which is simple, whatever else, and then fencing it, you want that listed so that they can be charged under the Gang-to-Gang Act.
That is
If
so.
that's part of their activity.
That is so.
As opposed to a man walking off the street, thieving a TV and carrying it to his house.
That is so. When it's further.
That's not a gang member, right? So you need, right, and the person who is maybe doing the fencing, that is maybe a well-established, licensed, use equipment dealer, could also be charged for receiving.
That could be.
Okay. I'd be advised by the legal minds.
Yeah. Just want to make 3 points. First of all, this is really a matter for you, because the law gives you the power to amend the schedule.
Yes, so once I have the advice,
Yeah, but I appreciate it being brought here.
Right.
And it was deliberately set up that way to facilitate that list being adjusted over time as
Right.
considered necessary, without the need to bring an amendment to the act
Right.
or something. Secondly, the concept in the legislation is serious offense. You know, people come together for criminal purposes in the form of the commission of serious offenses. So the listing in the schedule is of offenses which would generally be regarded as serious offenses. So what the DPP is really asking us to do
Yes,
is to categorize simple larceny and receiving of stolen goods as a serious offense for this purpose.
When executed by gangs.
Yeah, we're only talking about offenses when
Right.
executed by a gang. All right, that's all we're discussing. What offenses done by people collectively as part of a criminal enterprise ought to come within the gang legislation with the serious penalties that attach to that. So you could have, 4 youngsters who come together and, have a mango stealing ring or something that's, something non-commercial but nevertheless unlawful, and they could be charged with simple larceny, I think, or if we added it to this, they could be charged under this legislation. Now, this legislation wasn't really targeting that type of situation at all, and this is the difficulty of drawing the line. The intention was never to bring collective criminal conduct of a relatively minor nature within the scope of this legislation, because the penalties under this legislation are potentially severe, and the procedures take into account the nature of organized crime, the trial procedures that we've been discussing. So when I saw the letter from the DPP's office, I was at first a little, I wouldn't say disappointed, but slightly surprised that in order to prove a gang offense, they needed to go so low, as it were, in the totem pole of offenses as to get to simple larceny and receiving of goods, as opposed to gun-related offenses or serious offenses against a person. However, if in their experience it is necessary for the successful prosecution of gangs who are involved in serious activity that we add these two these two offenses to the schedule, I wouldn't object to it. I think a certain amount of appreciation and deference has to be paid to the DPP's office based on their experience in court of prosecuting this legislation in practice. But I thought it was important to make those remarks so that it can be put in a context as to really where we are.
Mr. Chairman, based on the narrative that one is hearing now and recent reports, it seems as though gang activities take on a whole range of matters. And so, for example, one hears that they steal goats. Pardon me?
Phones.
Yes.
Yes.
And so
That's included, yeah?
there are all sorts of things.
Pre and last is included.
And indeed, taking into account what the member Golding has said, when you see offenses like under the Wildlife Protection Act being included, and for example, that they take turtle eggs and so on, that is more to me, that is stranger to me than the whole aspect of larceny, because I can see where they can have a ring where they will benefit from the proceeds of the sale of these items. So having followed very closely recent events, I understand why the DPP might think it prudent to have it included, and so I personally support it.
Chairman, may I just say, may I just say, while I support the inclusion, but we don't have to say simple larceny. Just put larceny. Because when you say simple larceny, these are tried in petty sessions, and the parish courts. So if we put larceny, it embraces a wide range, So instead of simple larceny, you see, which sounds
the DPP's office
better
knows that.
than having simple larceny.
But they are very specific. They cited the section.
AG.
Thank you, Chairman. My apology for arriving late. I did not have the benefit of the full presentation, but I glean that
There's a letter that was circulated by email.
we're discussing what offenses should be included in the schedule. And the recommendation, yes. I've quickly seen the recommendation from the DPP's office in the July 10 letter.
Yeah.
Right. Just to say that notwithstanding the design of the legislation and the deliberate inclusion of serious offenses, perhaps a counterintuitive perspective needs to be looked at in terms of the kind of activities that gangs engage in. And many times we overlook the simple little things which are the foundational activities, which empower them and enable them to then carry out the bigger acts of criminality and also to gain control of a particular area. And I think beyond the specific recommendation, we need to be mindful of that, the reality of how criminals organize themselves, how they gain control when they start with things that we might overlook because we categorize them as simple, but the impact that those acts have on persons who are within the space. I mean, it's extremely traumatic for you to have your person picked, to be robbed, to have your house broken into, and little by little, the confidence is gained, and before long, there's displacement. So the wider issue, in addition to the specific recommendation of, based on all that has been presented, what it is that we need to include in order to effectively target the activities.
Yeah, I think, sure.
Be permitted one last comment, and I think it will be useful for us to look at what Section 5 says, because of the Larceny Act, which is what specifically the DPP was suggesting. It says stealing for which no special punishment is provided under this or any other enactment for the time being in force shall be simple larceny, and a felony punishable with imprisonment with hard labor for any term not exceeding 5 years. So although the term simple larceny is used, it really is speaking to serious offenses.
Statutory offense as triable in the parish courts, notwithstanding the penalty of 5 years, which is above the regular 3 years, but is this regarded as a special statutory summary offense?
I appreciate that and make sure we follow through. Mr. Williams, you seemed, SG.
If I may, Chairman, so the legal team has been considering the matter over a few months because we were also privy to the letter from the DPP, and it is a bit of a strained construction to put offenses like simple larceny, for instance, in this definition of serious offense, or to include it in the list. And so when we were having our discussions, noting in particular that there is now a joint select committee reviewing the bill, we thought it may also be an opportunity for this joint select to consider the construct that is here. And in fact, Parliamentary Council had suggested a construct where we not talk about the serious offense, but applicable offenses, because the thing is, at the end of the day, you want, which is what the AG was basically saying, that there are a number of offenses that you realize over time, and it may change, that the gangs use to be able to carry out their business and to create fear and harm and build up their finances. And it can morph over time. And so the CPC had suggested a construct of applicable offenses, which we support as well. And I think this would be an opportune time for the Joint Select Committee to consider using that construct. And then no, we wouldn't have this strained construction of trying to fit in all these different types of offenses into what is to be a serious offense.
That was elegant.
Said by the Solicitor General, Chairman.
We certainly follow that guideline. We proceed with the support of. Is that something you said?
PC is a substantive lawyer, you know, not just a draft.
So she will ensure amendment to construct for this schedule. Thank you very much. No, it's really, you know, we've now moved to the summer we're doing and page 760, but you know.
And that means the recommendation is accepted. Just so the DPP can report and the record can reflect.
The Minister will work with your department to get the proper construct. Yes,
sorry. Minister, if I may, the proposals that are made are with reference to the schedule to the Act. If the schedule to the Act does not refer further to serious offenses, yet we will change it by amendment to applicable offenses. At the same time, appreciating what Madam AG has said, having understood better what gang activities are and their reach, we're now in a position to make further proposals for amendments to the schedule to add other applicable offenses that should be considered, and we have detailed them here. For instance, we have highlighted offenses under the new Fisheries Act. When you consider explosive devices, grenades, for example, we had a situation, it was reported in the paper, where criminals have thrown grenades at police officers, one was injured, etc. So when you really look at the mode of operations of the gang, we have highlighted several that we should consider for amendment and inclusion in the schedule, or as the case may be, no longer serious offenses, but applicable offenses, and they're detailed.
Where is that list?
Remember, opening said the legislature designed this way that they are in the schedule, which allow them to amend, but I will certainly amend with the advice of the legal team at all times. So the proposal in the letter I've sent is accepted. We'll proceed to do that in consultation with you.
Just to clarify, Minister, the current scheme of the law is to specify serious offences in the schedule which apply. The recommendation is to revise that scheme and to move it away from the serious offences to applicable offences. But the power to amend would still reside, and it would still be the same method, so that a longer process would not have to be resorted to.
All you're doing is changing the nomenclature of the term from serious offences to applicable offences,
so
because you want to include offences which are not really generally regarded as serious or not that serious. But you just mentioned you have an extensive list of additional offences you want to
We
add.
have provided
but we
a
haven't
few
seen
other offences.
I'm picking up, Member, is that there are other things that will come on the applicable offence when it is executed by the gangs. And based on the experience, they're identifying such issues now. Am I right?
That is so, Minister. As well as what I'm interested in is the efficiency and how we can treat with the inclusion of these offences, because the matters are coming up. And whereas we consider the offences generally as serious, amending the schedule would be by order, which is a simpler mean than amending the principal legislation. So before we start or commence the other matters, we'd want these offences to be included in the schedule.
Yeah, but don't you have an issue? I mean, in other words, if they're not in the schedule now, and the offences for which you'd like to charge them have already been committed, then if you put them in the law now, it's not going to have retroactive effect. So that's an issue I need to consider. But I would like to see the list that you're proposing in writing. We saw 2 offences in a letter, simple larceny and receiving, both statutory offences. What I gather is that they have a longer list of things, offences under the new Fisheries Act, fair enough, but there were other explosive offences and others. Why can't we see the proposed list?
Let me ask, as the AG comment, what I'm getting is that we'd like to amend in the schedule, add a section for applicable offence, which is required to be a legislative change. And then under that, now we can include a number of items as requested here. But the suggestion I'm getting, something like a grenade would not come under applicable offence, that would be a serious offence.
Just to reframe the issue, we are in the process of review of the legislation, and a number of suggestions have been made as to how to improve on it. Right now, the DPP has proposed an amendment to the schedule to include an offence or offences which are not currently categorized as serious offences, but are important offences given the modus operandi of the gang.
Not just that, some of them are new offences that didn't
Right.
exist before,
All right.
like under the Fisheries Act.
All right. So there are a number of things that we have to take into account, and not intending to trespass on the terrain of the DPP, but I would hope that in looking at what to indict for, you're not necessarily caught up with the form, because if you have credible allegations that someone has committed an offense, you may charge them for the commission of the offense, notwithstanding that you're proceeding primarily under the anti-gang legislation. And if the rules of joinder apply, then you can try jointly. I mean, I don't know what the specific circumstances are, but if it is that you're looking at offenses that are now on the book, that were not an offense at the time when the allegations were made, remember the important issue of retroactivity. So you'd have to do your own assessment, but as far as the work of the committee is concerned, the recommendation is to include these offenses, firstly, and as part of that, we consider a revision of the scheme, though it may appear to be just nomenclature. But I'm sensing that you were asking that even before the rest of the reform work be done, that a consideration be given by the minister to amend the schedule by order, to enable the DPP to do certain things.
That is so.
Right.
For future matters, not only because we're charging persons daily.
Right.
So tomorrow we might have another matter that we could have indicted.
So even outside of the Joint Select Committee's review, the minister is given a discretion to deal with those matters.
As per section
And
18.
so 2 tracks can be considered.
That is what
bearing
I'm
in
asking.
mind other rules that would apply, Minister.
That is so. I understand
Mr.
that
AG is suggesting that we don't consider the list here. Is that what you're getting?
No.
Okay. So
I
all I'm
understand.
asking for then is, can we see the list that you'd like to add?
It is being photocopied for circulation, but I can go through in the interim, or if minister chooses, when we have.
Once you circulate
the
it,
copies.
we'll get it circulated to everyone.
Very well.
Okay? decision on this is clear, that we'll have two-track movement. I'll have to do the orders. And so
Chairman, what is being suggested for inclusion may require a little discussion, so don't close it down,
we'll
notwithstanding.
discuss them with the legal summary, but your recommendation is accepted pending the, I'll discuss the structure with the legal team. All right?
Very well, Minister.
But you'll get your wishes.
Grateful.
All right. Now we have the summary. I think you have them circulated. We go on page 16. We are going to new provisions to be included in the Act. We went through the earlier section by section of last week to the end, which took us to section 20. Now we begin page 16 with the new provisions. The first of which is tipping off offense. The proposal from MOCA that there be specific recognition of enhanced penalties for law enforcement personnel who are proven to be members of criminal organization and are actively committing the offenses prescribed in the Act. Recommendation was accepted. And there's a further recommendation. There should be a definition of the, now remind me of this one, there should be, and I agree, there should be a definition of political directorate to include cabinet members, members of parliament, mayors, councillors, that there be demarcation in terms of sentencing for such offences for the members of the political directorate, and that those from the political directorate who have executive responsibility should be separate from category of those with legislative responsibility only. Essentially, if you're a member of the cabinet and tip off anybody, we pay a higher price. That's the proposal, which seems quite reasonable. This now will have to be, Ms. Grant, will fall to you, right?
With the appropriate instructions, Chair.
Huh?
With the appropriate instructions.
All right. Got any comment on this, colleagues? This is now to include in the anti-gang tipping off offense, which I think is correct and reasonable, but okay. We move on then. AG.
Sorry, Chair. In this paragraph, in bold, there is a reference to penalties for law enforcement personnel who are proven to be members of a criminal organization,
right,
or are actively committing the offenses prescribed in the Act.
Right.
And that would be an aggravating factor at the point of sentencing, which is separate to the issue of tipping off, which is not in bold. And normally the recommendations are in bold, so I'm just trying to get a clear picture of what we're actually recommending. Are we dealing with tipping off, or are we dealing with law enforcement personnel who are part of gangs?
In the discussion, there was discussion on tipping off, which is an important part of what, I think that's how the second bold come in, to involve, to separate the political directorate who are members of the executive.
No, they're...
I think it was added in the discussion. It was added.
Oh, hold on. All right, hold on, let me read there.
So no further proposals.
So MOCA had wanted a specific offense dealing with law enforcement personnel who are part of gangs, and then it goes on to say this is in relation to law enforcement personnel who tip off criminal organizations. I think they're two different things, although they may have some overlap. So you have gangs which include law enforcement.
There are two items. There's those who are members of gangs.
Right.
Which
and there are those who facilitate gangs by tipping off.
Yeah, it's two separate
things. Two separate things, and both need to be covered.
Yeah.
Yeah. And then there's this third thing about political directorate, a definition of political directorate. And the idea there is that, and it's not very clear from this, But I think the idea was supposed to be,
If I may?
yes.
Because, sorry, Mrs. Masado had done some research going back over the minutes. And we think the recommendation should have really said, so where it says enhanced penalties, it should have said for not only the law enforcement personnel, but also for persons with certain high positions like the political directorate. I think they said senators, members of parliament, cabinet, mayors, etc. And they had also included justices of the peace. So that would have been in that first paragraph. That was a concept that came out of the minutes.
I think
Doesn't capture that.
this needs to be restructured. I think the
I know.
principle is accepted, but it needs to be looked at how the instructions are drawn, because I think what they're seeking here is to ensure that law enforcement personnel, those of us who occupy a sensitive position, beside, well, being a member of a criminal gang is one aspect, that's settled. If the law enforcement agency member is involved in a gang, that's an aggravating factor. But I think the second point was anyone in a position of privileged position of authority who have confidential information, who tips off a gangster, should be subject to.
So if I can just clarify,
Right.
sorry, I said minutes. It was actually our notes from the discussions. It's
So
not
in
really in
us
the minutes.
political directorate, I mean, well, I guess you'd consider FID law enforcement as well, but there are law enforcement officers and there who are members of that at level of the executive or not. AG.
And perhaps superfluously, Chairman, we do have a definition of political directorate in one of the policy documents in the Ministry of Finance, and it had gone through a process of defining it, and so perhaps for consistency, it covers members of parliament, members of municipal corporation, and so on, so we could just cross-reference.
Yeah, but it may need to be expanded.
Yes, no.
For this purpose. If you're going to include justices of the peace, for example, who should be included?
Well, not as political directorate,
Perhaps
though.
not.
Right, but
Yeah.
in terms of political directorate and the other category that would catch the others.
Minister, if I may as well, in our proposal for amendments to the schedule, we had actually noted that, and we suggested that it be modeled off Section 97 of the Proceeds of Crime Act, and also to include a provision which is similar to Section 104, which makes it an offense to do certain acts or omission that prejudice investigations generally, and it's applicable to anybody. So the categories are not defined here. So we have proposed that as amendment.
If that's already in the POCA legislation
It
and it
is.
applies generally, why would we need it in here?
Because specifically for the anti-gang offenses, if they're not in the schedule, then therefore they're not considered offenses.
They're not in the schedule of POCA.
No, sorry, if I might clarify, I think the poker tipping off offense really relates to money laundering, so it's not a general tipping off of offense provision. So this would be a tipping off in relation to gang-related offense.
But the other offense that you, in Section 100 and what?
104.
104 of the POCA legislation, he said was of general application. So I was asking if that's so, then why do we need to...
General in terms of they don't categorize persons or groupings, but applicable to the general public in terms of tipping off.
What offenses is it applicable to?
The offense of, 104 creates an offense of anybody who impedes the investigations generally. So we're asking that a similar provision be included
Why?
in the,
Why do, if it applies generally?
I'm sorry.
Why do we have to
under
duplicate?
POCA.
I don't think it's to offenses generally. It would be to money laundering investigations under POCA, not offenses generally.
That's not what I meant.
Understanding then is that this section will have an A and B section. A deals with members of the security force or members identified as a member of criminal gangs. B deals with whether law enforcement or position authority tipping off or conducting, carrying out activity that will damage investigation, right? And that must be. Am I right?
Chairman, I think we probably need to consider the general offense, because whether it's in relation to gang activities where persons are being investigated with a view to being arrested and charged and prosecuted, then any tipping off really perverts the course of justice. And instead of having to resort to to that. So maybe that is what we should consider, a general offense.
Is there no law in that? Is there no law to make that offense
across the board?
I think that's a huge step, actually, to create a general offense of tipping off in relation to any form of criminal offense. And we do, as the Attorney General has indicated, have offenses around perverting or obstructing justice. So I personally would just like to see an offense of tipping off in relation to offenses under this Act. And then if the persons doing the tipping off are law enforcement personnel or personnel who are part of the political directorate or other persons who ought to be categorized as being persons in authority like justice of the peace, then it would be an aggravated factor in sentencing. So it would be a tipping off offense for the purposes of anti-gang offenses, which would apply to anyone who does a tipping off, but would have more serious consequences potentially if the persons doing the tipping off are policemen, soldiers, political people, or other persons like justice of the peace. And then I think participation in a gang in any form, if you're a member of law enforcement, that ought to be an aggravating factor in sentencing as well, which has been proposed here.
That is agreed to without any.
Yes.
I think this tipping off, generally or otherwise. AG had
Well, Chairman, I have no difficulty with the suggestion of Member Golding, but I do not think that it excludes the wider consideration of the other issue, because it is this particular piece of legislation that is under review, but we're not looking at the work being done in isolation of the wider challenge that we face.
Yeah. No, I mean, I think if you want to consider that in the general criminal law reform, I think, that is that's a major step, and I think rather than come out just as an idea in the course of a discussion here, it wasn't even a recommendation from anybody who made presentations. I would be reluctant to include that in our report, that there be a general offense of tipping off, regardless of what type of offense you're tipping off.
I think then we'll agree. What we'll have is the two offenses here. One, the law enforcement person who is a member of a gang, that's a serious aggravating factor. And secondly, those who are in position, privileged position, let me say, layman's language, who tipped off gang members that may, in a manner that will interfere with the investigation.
Chairman, save and accept that in the course of the deliberations of this committee, we have looked at recommendations made, and we have also looked at wider implications. So it's not inconsistent with how the committee has conducted the affairs of the review of the act in question.
I agree. Some cases where it's been manifestly obvious that this would enhance things, but this one I agree with the AG that we should be a bit more circumspect with this one. But there's a third one, there's a third category, which I don't think you've picked up yet, which is to do with hindering investigations and so on, the 104 offense, which is, maybe you could just repeat the nature of that offense for the minister so we can understand it. And what we were told is that the offense which exists in the POCA legislation is limited to money laundering type offenses. And he's suggesting, the gentleman from the AG's office, from the DPP's office, is suggesting that it ought to be applicable to anti-gang offenses as well. Just explain what it is, what 104 covers, what kind of activity.
104 provides that this section applies if a person knows or has reasonable grounds to believe that an appropriate officer is acting or proposing to act in connection with a forfeiture investigation, a civil recovery investigation, or a money laundering investigation that is being or is about to be conducted. He falsifies, conceals, destroys, or otherwise disposes of, or causes or permits the falsification, concealment, destruction, or disposal of documents that are relevant to the investigation. And it goes on. So I'm saying a general provision should be included in the anti-gang legislation that addresses any hindrance of this type, falsification, hiding of documents, etc., similar to the provisions.
I prefer if you didn't use the word general, because when you say general, a provision which covers that type of activity in relation to offenses under the anti-gang legislation, right?
That's
what you're saying, yeah.
Next item we have is
Only question, sorry, sir, and that is, would the committee propose that if the party that is doing that hindrance, interference with the investigation is a member of law enforcement,
The penalties be graduated.
that it ought to be an aggravating factor? And I think consistently with what we've been saying, the answer ought to be yes. Yeah.
And in that regard, because I think it is useful that we have this recorded in the minutes, just in case we need to justify for some reason, someplace else, to explain why we are having an aggravated offense for a certain category of persons. Because if there's no proper rationale or justification, there can be a problem. And it has just come up in discussion, but we can't recall there being an actual justification for it recorded in the minutes.
Well, I would say that it's particularly insidious when you have persons who are responsible for enforcing the law or for making the law or running the country involved in anti-gang activity. And it's a very corrupting state of affairs which undermines the rule of law in the country in a very fundamental way. And therefore, that is a justification for an aggravated, it being treated as an aggravating factor in
the
sentencing.
Matrix did bring this up, you know.
I can't help but think aloud that two sides of Parliament have been categorized as the gangs of Gordon House. There was a time when front page editorial, the gangs of Gordon House. So, but fun and joke aside, I do share the view that we must send clear and unequivocal message in how we legislate and then enforce the law. You hold certain position and you become involved in certain activities, then probably you shouldn't see the light of day.
Thank you, Adrian. In fact, the minister did have something in here in the Joint State Committee. Given the problem of corruption in Jamaica, the fact is known that prominent persons in position of power and influence do have less than wholesome associated with criminal elements. There was merit to having this as an aggravating feature. Yeah, so it will be brought to bear on the reasoning. But that's from the minutes.
Sorry, sir, if you could just repeat that, I'm sorry.
I was just saying that SG had asked for a reason. I said in the minutes that we had, it was in fact brought up as to why it should be considered as for that particular group of persons. They said, given the problem of corruption in Jamaica and the fact that it was known that prominent persons or persons in position of power and influence do have less than wholesome association with criminal elements.
And I would include in that, for example, members of the office of the DPP.
Here, it's the general, anyone who was occupied as a political.
No, I think you'd have to identify what categories this uplift in potential sentence would apply to. And you know, the security forces is one, and the political directorate is another. And I think persons involved in the other aspects of law enforcement, like prosecutors and justices of the peace who issue warrants, and they all should be covered as well.
Was it clear, well, the draft report says law enforcement. Mr. Golden just spoke about security forces. Would we be including corrections officers, for instance? I think we'd have to be clear. Because, you know, sometimes when we say security forces, many of us only think JCF, JDF. So would it be also corrections?
Yes, because a lot of gangs are run out of prison. Yeah, so we have to include those people because they could be they can facilitate communication, which is vital. Yeah.
With those who are in a position of authority and who can have access to confidential evidential material. That's really what it means. Good. Next item, new provisions to be included in that. Compelling a suspect with an electronic device to provide the police access. It's the traditional repeated cell phone person which is blocked and how you get in there. It was decided not to accept the recommendation. Any second look? the recommendation was to give the police the authority to compel the individual who is in possession of an electronic device to provide the police with access.
Can that be
Which
done?
it would be an offense if they didn't provide with access. This was rejected. I'm not sure on what basis again.
Can that be done by way of a court order? Is there any provision in law that allows an application to court for an order compelling the
If the police access it without the permission of the individual, can it be used in evidence? I'm trying to understand from what was rational here. Okay, if they refuse access, their electronic means of getting access, can that be used in a court as evidence?
It can, Minister, because invariably when we retrieve electronic devices, we send them to the CFCU for analysis and to see if we can actually gain access. Sometimes accused persons would send it to the police to see if they can gain access to the device. Sometimes the accused persons would give you the PIN code or open the device and hand it over to you, and we keep it charged or pull the information from it before the battery dies, or send it to the lab or record the access information.
We rejected the recommendation. I don't recall what was it.
If I may, Minister, I think during that discussion, what was pointed out was that Section 17 of the Cyber Crimes Act already makes provision for this. It is a criminal offense where there is a production, is it a warrant, I believe, order? Yes, that has been issued for the person not to provide the PIN or access to the device, and there's already penalties stipulated for this, which I think was the main
This would be the application.
I would think so, Chair.
Call that discussion because it was more along the lines of how long they needed to keep the data and so on, but not under this legislation, but as you rightly said. All the companies were present, the Digicells and so on were telling us how long they kept the data. So I don't think this accurately reflects how we approached it.
I
think it was
recall
in the
that
discussion of
the
this issue?
technical team was not privy to those discussions, Senator.
But I think that's a different point. This is to do with access to the device. So that provision that you were referring to in the Cyber Crimes Act is a provision of general application. It's not limited to offences under that act.
It is a provision of general application.
Next item. Again, your committee noted the proposal from MOCA regarding the treatment of non-national being considered a member of a gang. The rationale being that if said person came into the jurisdiction to be involved in gang activity, that ought to be treated as an aggravating feature. The committee did not accept.
The idea was, I think, to provide a strong disincentive for foreign nationals to come here and participate in organized criminal activity. We know about the transnational nature of crime and the linkages with other jurisdictions and so on. And there are, and we've heard of operatives coming here and living here or getting involved in criminal activity here. But I think my recollection is there was some objection to the notion of treating foreigners any differently to locals for this purpose.
Chairman, while I do not now recall all of the details around the discussion, I'm wondering if the committee could reconsider and look at that as part of the sentencing, because the truth is that we do have different treatment for nationals and non-nationals, even constitutionally, in terms of even though the general fair hearing provisions relate to all persons who are present in the jurisdiction. But again, given the severity of transnational crime, perhaps consideration could be given that if on conviction it is a national and non-national, then certain other steps can be taken in the same way that you can do eventually things lead to deportation. I mean, we have a lot of examples of our own nationals being treated in a particular way in other jurisdictions. I don't know. I mean, if we really are getting to the root of the problem, we can't disregard genuine concerns in relation to the procedural and substantive rights that we have guaranteed to all persons. But I certainly have no difficulty in looking at someone who has come into the jurisdiction in the face of the challenge with the transnational crime, and perhaps as a matter of sentencing upon conviction, that be taken into account for sentencing purpose.
I'm AGM leaning that direction, that I would suggest the committee look at it again, because one of our major problems with the gangs in Jamaica, several of the more nefarious gangs are supported by individuals who are based overseas, some of whom may be Jamaicans, but some may not be Jamaicans, even originate in Jamaica. And that has become a big problem, because it is extremely difficult under those circumstances to, in fact, overcome or prosecute that gang. Well, maybe that's the right term. Like if you prosecute 5 of the members of the gang who are the face of the gang in Jamaica, they are the killers, the shotters, or the extortionists, then pretty soon the person recruits another 5. It just keeps coming, because they are not, the leaders are not based in Jamaica, they are based elsewhere. And they visit from time to time, but there is no offense committed in Jamaica by them, at least not, easily prosecuted. So if we can identify them with a gang when they get here, it makes a lot of difference. I don't know, I could be something worthwhile considering. So we'll look at accepting the recommendation.
Any contrary suggestion, then we could reformulate that recommendation.
It was the power of search and seizure. The recommendation was not accepted. Your committee noted the proposal for the power of search and seizure to determine whether there should be a default position which required having a search warrant, and then examine the circumstances that may permit search without a warrant. Your committee decided not to accept the recommendation, but recommend that the issue of search and seizure be addressed as a consequential amendment to the Constabulary Force Act, with sufficient parameters that is being linked to a schedule where the types of circumstances were listed and identified was taken into consideration what the Constitution guaranteed and prohibited, as well as the standard of derogation, subject to the necessary checks being undertaken by the AG's chambers. Okay? We can move on. Forfeiture of assets upon conviction. The committee decided not to accept the recommendation, but agreed to the inclusion of a provision that allows the court to make an order in relation to any subsisting contract the person is party to with any public sector contract, with a view to ensuring that justice is done in these circumstances, subject to and take into consideration the language, reference, precedents, and constitutional requirements being addressed by the technical legal team. No further comment? Okay, move on.
Would that drafting give any indication that what would be the aim, if it can be done, would be to put an end to those contractual arrangements? In other words, just to say that they can make an order in relation to a contract with no guidance to the court as to what the policy is to be followed in exercising that power. I'm just thinking in the drafting of it, it would be useful if there was some indication as to the intent behind the provision, which is essentially to ensure that persons who are benefiting from public contracts in the course of criminal activity ought not to be facilitated, or to put it the other way around, or not to, unless it would be somehow injurious to third party the rights, or yeah, you know, yeah.
I think that was the last paragraph.
Execution of his duties.
It's raining hard. It's raining hard.
Yeah. Officer of DPP and the committee know the proposal from the officer DPP assaulting of a police officer in lawful execution of his duties to incorporate a provision to criminalize the act of preventing an officer from lawful execution of his duties, coupled with the appropriate sanction, would act as an effective deterrent. We noted the reference to Section 30 of the JSC Act, which was a common law offense. A penalty was provided for statutorily. It was updated by a consequence of amendment to the Law Reform Zone Special Operations and applied generally. The fine was increased to 1 million, which was the final jurisdiction limit of the parish court. Anybody wish to look at this again in the context of gang activity? Members, right? All right. We move on then. Though gangs threaten a policeman is a different thing from one threatening a policeman. I will look at the next proposal of assaulting a police officer in lawful execution of his duties. The committee decided not to accept it because there is a provision on the Constable Force Act.
General provision, Chairman, I have to say that I sometimes feel concerned about the display of lack of knowledge of the powers that are available generally in policing. So it is from that perspective that there are general provisions that are available. Similar provisions have been made to persons who carry out certain functions but would not benefit from the protection that is under the Constabulary Force Act. But there is no need to replicate, and that is why you legislate with general powers, and then you can condescend to specifics depending on the area.
Accept if it is not a major problem yet. Corruption may be a major problem, but assaulting the officer is not a major problem. It's come under the, I guess if that's fine. The next item is pre-trial detention, which is a pretty contentious one. Your committee noted the proposal from the MOCA again, the JSCF, and the officer of the DPP for pre-trial detention for a period of 7 days, possibly extended to 14 days. The committee decided not to accept the recommendation and noted that the issues related to pre-trial detention are being examined in the revision of the Bail Act and would be revised therein.
Yeah, we kicked that can down the road.
Just kicked it.
Yeah.
Road.
But
the loud noise.
A pre-charge bail has been considered for a long time because it started, but there was a lot of hostility towards it.
In due course, I think we will discuss this issue, because I assure Member Golden that he will be very surprised when he discovers what is or isn't on our statute book.
I don't think I'll be the only one, because it's quite clear that there are all sorts of things on our statute books that our law enforcement personnel aren't aware of, and it speaks to the issue of training, you know, that we need to really...
Yes, I have noted that in this committee that...
The Justice Training Institute perhaps ought to have a module for training persons in law enforcement, including lawyers, on what legislation exists and legislative provisions exist as tools to help them.
Just by way of hint, Chairman, a certain suggestion has been made to borrow provisions from other jurisdiction covering a particular area. And the exact provision is actually on our statute book, but we will come to that.
I won't say training, I say we need to sensitize all the enforcement officers, from lawyers to police and the issues. Those who are fully aware of the details, and AG, that might be your office responsibility, but the SG to go sensitize all these people to, all these professionals to what is required. Production or inspection orders. Your committee noted the proposal from JSC for a provision that allows the police to apply for production inspection orders and account monitoring orders in furtherance of an investigation of the Act. Again, was this already provided for, or not? We did not accept it.
I mean, on the face of it, I mean, we had a lot of discussion about creating, for example, a menu of heightened investigative powers in order to facilitate more effective investigation of offenses under this Act. And things that we had talked about was access to financial records, interception of telecommunications, and knowing when persons are crossing borders, international borders. We had discussed all of that. I don't know if that made its way here, but I don't know, on the face of it, I'd love to know the explanation as to why we wouldn't want, for example, account monitoring orders to be something that you could...
Just to clarify, the way some of the recommendations are put, it's not that there is an outright rejection, but the real question is whether we need to put it in this law that is under review or provide for it generally. Right, and where the provision, where a recommendation is all covered elsewhere, that is part of it. So it might require some clarity. So it did not accept the recommendation because the provision is contained in whether it's a POCA law or wherever, or that further consideration be given to amending the Constabulary Force Act and include it there.
I think in this case,
don't just leave it hanging.
I think in this case, it was suggested there might be other legislation covering it. And
but look, the report has to say where. You know, in other words, you can't have just say you don't accept the recommendation and it's as if you don't want them to have these powers. The point is these powers exist adequately elsewhere, and this is where they exist. And it should be
very
stated.
important point, Chairman, because the report is not only going to be read by us who have the background knowledge, but someone who has not been part of it, who takes it up, it must make sense to them. And I'm designating SG Aldred to assist Madam Clerk.
Thank you.
Thank you, ma'am. Yeah, we need that because, as I said, reading it in isolation or without the background may give the wrong impression, the wrong signal. And that will want to make the headlines to somebody reading it. Right. Protecting the gangs of God knows again. Repeat offenders. Again, this one, why wasn't this, why the rejection of this particular item? The committee noted the proposal of the MS.
Chairman, just, belaboring the point, but not to do so, just repeating for emphasis, where the provision exists. So we have Criminal Justice Administration Act, we have Criminal Justice Reform Act, we have provisions. If they are covered elsewhere, just point the reader to there, and it also serves as a reminder to those who must use the law. And as we...
In fact,
I know, so I believe just noting
the right way to do that
you know, you have
would be
to
to point them to where it exists and recite it in a footnote, so you can actually read the provision that we're saying covers it, or an annex, a schedule or something. But I think one area where this ought to be considered is in a lot of scam legislation, where we see first-time offenders getting very, very light sentences. And the question is, that may be an inducement to repeated conduct because it's probably very profitable. So the question is, ought that not to be addressed there?
This is a vexed issue that Member Golding has raised, because the better view is that where a particular conduct or misconduct is creating mayhem as a matter of policy, legislators can say, if you engage in this, given its prevalence, its harm, and all of that, at a minimum, even in the most favorable circumstances, this is what you are going to be liable to be punished for as a matter of policy. But bear in mind that when it comes to sentencing, we legislate maximum sentences, and a court will take any of many considerations, including whether you're a first-time offender, what your antecedents are, etc., etc. So there are general principles of sentencing that come in. We will have to make a decision on where we are setting the policy line.
Well, a lot of scam is the source of funding for many gangs, but the point made, I think, is, I'm not sure we would bring this, but I'd like to note it. If you have, there is reason for not so much minimum sentence, but repeat offenders to be particularly given more stringent sentences, because the initial lot of scam may be just some youngster who has acquired the skill and decide to be a part of the system. When he realized that he could end up with a long-term jail sentence, he will, after the first offense, he may change his behavior.
I mean, what we
He gets
see,
a life sentence, but if he keeps coming back every
that's
2
the
years,
issue to me.
then you have to deal with
I
it.
mean, if the courts have what appears to be to someone who's not in the courtroom and is just reading a newspaper report,
Right.
and that is, always a dangerous way to judge the matter. So I preface my remarks by that. But on the face of it, you read it frequently that persons who are just, for example, in possession of identity lists and have no previous convictions for anything, and they're young, they get very, very light treatment. All right, and we know that scamming is very profitable. I mean, so those sentences must be an inducement to continue. So I'm wondering whether there ought not to be something to counteract that inducement by making repeat offenses.
That makes sense.
A provision for repeat offenses being treated more seriously.
So we do have provisions in relation to repeat offenders, but the member is treading on an area where there are diverging views. So there is a question of mandatory minimum sentences, and there is a question of maximum sentences, and there is the kind of discretion that you give. Bear in mind that when our model is really a maximum, and it doesn't mean that the maximum is going to be applied. On top of it, there are sentencing guidelines. On top of it, when you're dealing with young offenders, there are general principles that apply, not just in this jurisdiction, but across both common law and civil jurisdiction, which are almost embedded in the jurisprudence. So we have to be clear in terms of what we are legislating and what policy positions we are taking for sentencing, bearing in mind that it's a vexed question. So immediately I hear the member saying, I ain't going there, but to a certain extent, if we're raising concerns about whether a first offender, a young offender, is being sentenced too lightly, and that may induce him to think that, sure, no, I get a tap on the wrist, I can do it and come again, because they are so invested in a lifestyle of criminality. If that is a legitimate concern, and we have evidence, not just because we feel so, to consider it, then it's going to take us into some contentious policy realm. And we have to have the appetite to deal with it.
I'm not in favor.
I appreciate that, but I said the basic policy issue is whether, well, clearly for a young offender, I can see a reason for a life sentence, a first-time young offender, but the person keeps coming back. What stage do you say, no, look, he's made this his professional career, you have to stop it? But I know it now gets into some delicate waters of instructions to do, well.
I can assure you there is no demilitarized zone. It's a thorny issue, because if we're leaving it entirely to judicial discretion and sentencing guidelines, and we read the sentences that are handed down and without more, I think you rightly recognize that the reports do not generally capture all that takes place. but invariably I've heard more expressions of concerns about whether the sentences are proportionate and whether they are discharging that deterrent function of sentence. Because, to have would-be criminals look on and tremble and think twice before they embark on that type of criminal conduct.
I think we're talking about lot of scam. In this case, however,
Yeah.
the penalties are quite severe under the Anti-Gang Act, and therefore I don't know if we need to, where it was not accepted, so we could move on. This.
I just want to clarify, I am not suggesting a mandatory minimum sentence provision, but I am saying that a person who commits an offense and is convicted and gets a very light treatment because of the circumstances of that should know that under the statute, if they come back again, it's going to be a much heavier situation they're facing. So I think that signal ought to be the deterrent, because the law should provide for a heavier treatment of a repeat offender.
Believe it or not, member, to a certain extent, that is the realm in which we're going. Because if you're saying first time is one, second time, a minimum of, it's not going to be left up to entirely a discretion. You can go up to a maximum, but there is also a floor below which you won't go.
I wouldn't know from a... I'm sorry, but when you get an offender go to court, when they have to be sentenced, are the previous convictions taken into consideration?
That is in fact correct, Mr. Chairman. First of all, the judges, they're going to ask for a probation report, or they're going to ask for a social inquiry report, etc. The probation report is going to list the several offences or offences that would have been that the person would have been convicted of before. It would also set out what the fine was or what the punishment was, etc. And in those circumstances, we have to maintain the sort of legal regime which actually does allow for judicial discretion, and I believe in several matters, several constitutional courts across the world have actually commented on a sort of, removing, fettering the discretion of the judges. So I don't think I agree with the fact that we did not accept it at this juncture here, and I believe it could it ought to remain as is.
Yeah, I am not suggesting it become a mandatory minimum situation in the repeat. I'm just saying that the fact that you're a repeat offender ought to be an aggravating, something that the court can treat as an aggravating factor in sentencing. Maybe that goes without saying. It may go without saying, but I don't practice in that area. But
you're referring to not a scamming, which is it's a part of this, there's sub part of this really. But my understanding of what is being said, there is such a thing as sentencing guidelines. So it could come
Chairman, can I just... So the offences are in the second schedule. There is actually one offence that carries a more serious offence if it's your second or subsequent offence, and that is for the offence committed under Section 6, being a part of, participating in, or facilitating serious offence. It's already there, so you have the first offence, page 23 of the Act. Well, my page 23.
We can move on then.
But it's there for one. But I think, I was going to say in relation to the report, I don't think the heading should have been repeat offenders. I think the heading should have been mandatory minimum sentences, because, as I recall, the discussion was mostly around mandatory minimum, and that is what the committee did not accept, mandatory minimum sentences. So I was just saying, we can look back at the minutes, but I think that would help to clarify what was in the report.
I recall you're correct. That was a discussion about there. All right. Restitution.
Is that there was a serious split in the view of the committee on this matter of mandatory minimum, Chairman, if the minutes are to accurately reflect the deliberations of the committee.
Was not accepted.
Just before we go, I think though for accuracy, there must be some capturing of the discussion and the concern relating to the repeat offender. So we'll have that very well.
And again, with this one about restitution, I think the reason for it is because it already exists as a general provision in the law that was added recently. So, yeah, I can't remember
So
where
I was going
find
to
it,
say
but yeah.
that it's not that the committee did not accept. The committee agrees in principle, but it already exists in the Criminal Justice Administration Act.
All of
So
those
you
need to
don't
come
need to
report.
put it here. So we will have,
In fact-
we will assist in fleshing out the report.
If I recall correctly, there are quite a few items. In fact, the discussion that was raised earlier came up quite extensively in several other sittings, that there were legislative provisions which are not being used effectively. And I think
That one is quite new.
Yeah.
This one, I think it was enacted last year.
another touchy one, declaration of a criminal organization.
Perhaps as part of the reformulation is to specify where there was agreement in principle for the recommendation, but because of its inclusion elsewhere.
Site where? Yeah.
Criminal organization. I've heard this one causing contention among the lawyers. The recommendation, what is the recommendation here? That will not accept it. I know there is in law the right to declare a criminal organization. What were we rejecting here?
There is no such provision in our law.
There is no such provision.
No, there was a proposal arising out of Australia, one of the states of Australia. Mr. Bailey stepped out, but he's familiar with it, where I think in relation to Hell's Angel bikers, there was a provision for...
So what we have here? We have declared gangs.
We don't declare gangs. You can be convicted of an offense under this act. If it is proved in court that you committed a serious offense, which is going to be an applicable offense going forward, in the course of being a member of a gang. So you have to prove the existence of the gang in court. There's no provision for declaring it in advance or anything like that. Yeah.
Let me just repeat one of the concerns that I had raised is that the gang is just a small part or a subset of the criminal organization, though we have dubbed the legislation anti-gang. And that is why I had raised ex ante whether we should look at the criminal organization and that definition in a way. I mean, I can understand, the member who had piloted the law was strictly in defense of letting it remain. But I still, though it's a committee and it's an overall committee, have a little bit of unease about the formulation of the criminal organization, meaning the gang, the group, the alliance, the network, etc., in the context of our domestic reality.
We've gone over this sort of ad nauseum. I don't know if you want to go over it again. I just think that it goes to the heart. It goes to the heart of of the legislation. That definition is at the heart of the legislation. They have a load of pending matters, including part-heard trials, which are dependent on that. I would be loath to tinker with it. On that definition
of criminal
of a criminal organization in
that's
that.
repeat that again.
The definition of a criminal organization in the act is at the heart of the act. All of the offenses flow from that definition. If you go and tinker it by amendment and so on, it's going to impact, I think, matters that are pending before the court. And I think that is, I would prefer to have those matters adjudicated and we find out from the process of trial whether there are any issues with it or not before we go and preempt that. That's my own view.
Another response. The member is defending the work that he did, and I understand. I mean, I don't mean it in any way.
Put it in those terms is not particularly helpful. If there were no pending matters before the court and you thought you had an improvement to make to it, we would look at that and its merits and decide whether there is any merit to it. So far, we haven't even seen a specific proposal, other than you have some nebulous concerns.
I
I'm
hear-
not trying to uphold my work. I'm trying to ensure that pending matters, at an early stage of the life of this legislation, you've said there are a lot of matters that are now in train. Some of them are actually partway through in a trial, which are going to be of very great importance to the future of this legislation. I don't think we should be doing heart surgery on it until
hear
we've
you.
heard what the outcome of those.
I hear clearly what you're saying with the AG's comment. I find interesting. I would agree we wouldn't think of it now, and in fact not think of so much, but I always find it strange that another jurisdiction, individuals who are not even near there are declared kingpins before they come to court. And then, how do you try that as individuals?
That's a different issue, Chair.
But
The
Chairman,
procedure of declaring somebody a member of a gang, and whether the law should have such a procedure is a different point to whether we would change the definition of what a criminal organization is. We had discussed the practicality of a procedure which allows you to designate an individual a member of a criminal organization without having that matter tried in court. And we didn't think it was a practical approach. And it hasn't been used in many places. One example of one state in Australia was cited, and it was in a very narrow context.
Chairman, we can proceed.
I will note it, not for the mayor. The next item is proposed penalty for owner occupier of premises used for a commission of offense. The committee accepted recommendation to include Section 5 of the Law Reform and Fraudulent Transactions Special Provisions Act 2013 to penalize the owner, occupier, or person responsible for the management of premises who knowingly causes or permits said premises to be used for the commission of offences on the basis that the Chief Parliamentary Council et al. Would address the wording to address the issue of knowingly causing the premises to be used. Does that reflect the thinking of the meeting? B, of course, decided not to accept the recommendation regarding Section 5 of the Law Reform, Fraudulent Transactions Special Provisions Act, regarding an accused being unable to properly account for property which is disproportionate to a known source of income, and noted that the matter was to be reviewed in relation to the Proceeds of Crime Act. Well, that's accepted, and that's being done, I think, at this point. Okay. Any comment?
We accepted that the inclusion of a new offense relating to premises and the use of premises in furtherance of gang activity, that was accepted. The other one, which is to do with persons who can't account for their assets and income.
Proceeds of crime.
Yeah. We noted that the matter was to be reviewed in relation to, when is it going to be reviewed and by who?
The Proceeds of Crime Act is currently being reviewed, and I expect this to be included. In fact, it's near completion now, as far as I understand. Mr. Richards, the Proceeds of Crime is going through its last phase of revision, right? So we'll check if this is included at this point, and I'm sure it's included. What the primary
inclusion
legislation
would be that we would make that a general offense or an offense in relation to money laundering.
Minister, I have to say the unexplained wealth provision was not included. That is something that we will have further discussions with ourselves, Attorney General's Chambers and the FID to advance that proposal.
There's an offense of illicit enrichment in the Corruption Prevention Act, which remains, it has not been repealed. And it applies, I think, to public officials. So I'm not sure, but it exists, and many people think it ought to be utilized more extensively. But it's something similar that it is being proposed here, but to make it of general application. Is that the point?
I'm not quite clear, and I'm not sure this is yet there. The director was suggesting it's not yet in the group, but they could look at it. Well, they're doing the final revision now, as far as I'm aware. You have had your comments already, SG.
Poker is with, it's back with us? Oh, okay. CP is working very quickly.
I mean, this is always been a kind of last round of revision as far as I'm aware. It's both the primary legislation and the schedule that's being amended, and it has been to the CPC and to SG with some further recommendations, which we expect to complete the process. Right. All right, today. All right.
But, you know, this provision is in the latter scamming legislation. And the proposal was to have something similar in the anti-gang legislation. And what we're being told is, no, don't do that, because there's some review going on of the poker legislation. Though I must say the dialogue around that doesn't inspire one with a lot of confidence as to where that is and where it's going.
I think this should be there somewhere. I'd like to know, be sure it will cover, the process of crime will cover it, or do we need to take a second look and include it in the Anti-Gang Act?
How long is that review going to take before?
No, that's
no,
proceeding.
Well, before it becomes drafted into legislation. You know, this report, once we finalize it, can be, I hope, fast-tracked into legislative activity. Which
the process of crime is proceeding speedily. And mind you, it is to come to the host. In fact, the intention was to bring it before the end of the month, but I think there have been another round, and it's just back there. It's due to get here certainly early in October.
But just to clarify, Minister.
They don't seem to have contemplated the unexplained wealth aspect of it, which is what we're referencing.
So unexplained wealth is not included in the process of crime act, so where do we put it then? Because we need to get it in.
Sorry, Minister, if I may just try to offer an update. So there were issues with the proposal as it was submitted. To be fair, the CPC gave us a draft. Now, there were some issues going back and forth, including ensuring that the proposal as it is was able to stand the constitutional muster. So we should be having some further discussions between ourselves, CPC, and the AG's chambers. But in order to move forward with the technical compliance for poker, we have taken out the unexplained wealth provision at this time, and our intention is to advance those as soon as we have completed this.
So that's all to do with CFAT-F, isn't it? That is all to do with that.
And let me, it's coming back to me clearly.
Yeah.
Yes, we're trying it.
May I though?
If I recall before I come in this year.
No, but I'm looking at the proposal here, which was, the proposal was to put in section 15 of the law reform fraudulent transactions, to replicate it in the anti-gang law.
You turn this with that.
And I don't see why that can't be done.
Mm-hmm.
Yeah, because the unexplained wealth issue in process of crime came upon us posing some, I'm not sure whether I should use it. And it was agreed that we would extract it to meet our commitments and the CFAT requirements. So that is coming to Parliament. Should come to
But a thorny issue like that will detain what you're trying to do in that area, and it's no doubt time sensitive. So let us deal with it through this mechanism.
And as she's saying, we can bring it back here. So
the section 15 that is in the
scam,
I'll read it. It says, in a trial for an offense under that act, the fact that a person A is in possession of property for which he cannot satisfactorily account and which is disproportionate to his known sources of income, or B, had at or about the time of the commission of the alleged offense obtained an accretion to his property for which he cannot satisfactorily account, may be taken into consideration by the court and is admissible as evidence to the extent relevant to any issue in the trial. So just replicate that in this law.
Yeah.
Right. And then forfeiture, if that was appropriate, would come under poker. Yeah. So that's already addressed, because we have added offences under this act to the second schedule of poker now, haven't we? That should have happened long ago, right?
Which of them?
Page 20.
Yeah, so we just need to do this then.
Okay, page 20. And then we can leave this out because it will change.
Okay, we'll have to do that. All right. The use of control orders. Further be done. Was that because we had alternative legislation? Yeah, Merle. The next item is still unexplained wealth, which is similar. We just discussed that. I expect similar item.
If you no want pop down and fenke, you fi burn mosquito and run with dengue. So no make water settle in open container. For them we read up under the danger. Usher them out, run them away. Zap them with the zapper and down them with spray. Use mosquito net and mosquito screen. Protect your household, now make them come in. If you no want pop down and fenke, you fi burn mosquito and run with dengue.
A message from the Ministry of Health.
All want white, bright, perfectly aligned teeth and smile. It can be had with good dental care and a little extra help from the dentist.
Dr. Denise Moore as she transforms smiles, transforms lives, one mouth at a time. Smile Bright, coming soon on PBCJ, the People's Station.
Hi, I'm Taurus Riley, and I'm here to tell you, this inflation thing is important. High inflation is a wicked thing, and we must abolish it like slavery. We want inflation low so we can plan and prosper. But if it drop too low, we can't grow. All the high prices that mean me harm, hey, they can go back where they came from. No inflation monster shall prosper, yeah. So that middle ground is what we want. Low, stable, and predictable inflation. Cause low, stable, and predictable inflation is to the economy like what the bass line is to reggae music. Listen up. Let the bass line roll and catch. Reggae music run the country like low and stable inflation of the rock the economy.
A message by Bank of Jamaica. PBCJ is now the source of information about Indian culture. Watch Incredible India on PBCJ and learn more about their homeland, Indian mythology, religion, food, music, and dance. Join us Sundays at 3 p.m. and Thursdays at 7:30 p.m. for Incredible India.
Predictable, stable and low. Targeting inflation to boost the economy. POJ committed to Jamaica and the economy. And the best way forward is using an inflation targeted strategy. Keep the rates them low, stable and intact, so consumers can buy more goods with them cash. Committed to make the economy grow. Predictable, stable and low. Inflation targeting the way to go.
Everyone knows what the pink ribbon stands for, but do you know what the gold ribbon stands for? Get the facts. Act now. I'm Renee Thomas, and I am a survivor. PBCJ recognizes September as a Childhood Cancer Awareness Month.
We live in a digital environment. where information is easily accessed and opportunities are limitless. An age to think big, to innovate and lead. But beware, the digital space has its challenges. Manage your digital self carefully, because the consequences are real.
At least 10 incoming freshmen had their recent acceptance withdrawn after posting extremely offensive images and statements on a private Facebook group.
Stop and think before you broadcast and post messages. Before downloading third-party apps. Because your digital footprint follows you wherever you go. The Broadcasting Commission, your partner for a new day.
As an inner city youth, I'm a duty to know my rights. Not because you see me on the corner, you are going to abuse me.
I have a life to live. I deserve to be heard and respected. I know my rights. Know your laws. Know your rights. Respect you.
PBCJ is now the source of information about Indian culture. Watch Incredible India on PBCJ and learn more about their homeland, Indian mythology, religion, food, music, and dance. Join us Sundays at 3 p.m. and Thursdays at 7:30 p.m. for Incredible India.
What happened, Tristan?
Mommy, what is an activate?
Activate? Where you hear that word?
A lady was on the TV and she said she is a children's activate.
Oh, the advocate.
That's what I said.
Okay. The children's advocate is the person who makes sure that people know and respect the rights of children. She also makes sure that they are protected. She makes sure that even the government does its job properly when it comes to kids.
Children have rights too, Mommy?
Of course.
So, Mommy, do I have the